Happy Friday, and welcome to Tenstreet's first compliance webinar of 2020, the new laws that will change the way you operate in 2020. We're really excited today. 2020 has already been an exciting year for compliance, and we are lucky enough to have our General Counsel, Shannon Wheeler here, who is going to share with us some insight as to what's coming. We appreciate you joining us on a Friday afternoon. I know sometimes that's tough, but compliance is important. It's important for, I think, everybody in our industry to understand and know what's happening out there in compliance. And of course, as we all know, compliance is one of the things that if we don't comply and we don't do what we're supposed to, it can shut our business down. And so it's really important, and we value that at Tenstreet, and we always want to be a resource for you and help keep you abreast of what's going on out there and really be your compliance resource. And so with that, I will turn it over to Shannon Wheeler.
Great. Happy to be here. Thank you, everyone. I am very excited. We have a lot of updates and a lot of new laws that have happened in 2019 and going into 2020. So we're here to talk about those things and to give you guys a heads up on what all is going to happen. And 2020 has already started with a bang with the Clearinghouse. So we have a lot to cover and a lot to talk about. So we'll just dive in. Here is my typical legal disclaimer. I know everybody kind of rolls their eyes when they say this, but I've got to say it. I'm not your lawyer and I can't represent you. So the following information is only educational information. It's not legal advice. As always, we highly recommend that you consult with qualified legal counsel on all of the legal issues that we are going to talk about here today. And if you need recommendations for legal counsel that can represent you and dig into these issues, I am happy to give those to you. You can email your account manager and ask for those, and that will get to me and we will make those recommendations. And then, of course, Tenstreet expressly disclaims any and all warranties associated with this presentation and the information herein.
All right, so what are we going to talk about today? So, of course, we're going to talk about everybody's favorite topic, the Drug and Alcohol Clearinghouse. We're also going to talk about the California Consumer Privacy Act, the California given AB5 update. We're going to talk about recent state ban the box and pay equity laws. And we're also going to talk about some significant case law that's happened recently that we think you need to know about.
Is everybody seeing the current agenda screen? Somebody type in on the chat. Yeah, I thought so. So let's get that changed where I know we've got the slides up in one area, and there we go. I think we're now. Okay, so there's the agenda. Awesome.
Great. So let's talk first about the Drug and Alcohol Clearinghouse. So hopefully everybody is aware by now that the ruling went into effect January 6th, 2020. And so just as kind of an overview, because we have a lot of different people on this call, is the reason that the clearinghouse was designed is obviously to help make our roads and highways safer for all of us. And it's really designed to be that repository for everyone in the trucking industry to report those drug and alcohol failures and refusals. And so it's up and running now. It has been running pretty smoothly, at least in the last week or so. And so we're excited about that. And we are working with FMCSA, and it's been a great journey to just kind of go through this and get everything going. So now that it is operational, what does that mean? That means that you have to run full queries on drivers before you can put them into a truck. And so we're going to talk about that. Full queries are pre-employment queries. And so first of all, those drivers have to register. So in order for you to run a full pre-employment query on a driver, the driver has to be registered within the clearinghouse. There's a lot of onus on the driver in this regulation. You can't, as a carrier, go and register the driver. They have to register themselves. They have to create a login at login.gov. They have to verify their CDL, so there's actually a two-step process for them. And then whenever they apply for a job, in order for you as the motor carrier to receive those pre-employment screening results, they have to, again, a third time, go out to the clearinghouse and authorize whatever employer it is. If they've applied for 5 companies, they have to go in 5 times and authorize all 5 of those employers separately to receive those results. And so that's quite a change as we're going through what the hiring process looks like for these drivers. That needs to be completed on every driver before they get behind the wheel of your truck.
So the reason why there's the full query process and the limited query process is it was initially designed to where it was just all a full query process for every time you had to come in. And this is, I think, a security standard that the government has set up so that drivers know what's being released and when it's being released. And so they actually have to go into the clearinghouse, register, verify their CDL, and then there's a dashboard or a page just like what employers have, just like what Tenstreet as a TPA has, and it will show the query requests and who has requested it. And then they literally hit a red button for I do not or a green button for I do. And so that will release the full query. And that is what has to happen per these regulations for pre-employment before you put a guy in a truck. And I know we've got some questions and we've got some discussions about the technical difficulties, and we'll cover that here in just a minute. But then just one of the, also, we've got a question right now, and it's one of the biggest questions that I've gotten in what about staffing agencies and what do they have to do? And it's a little murky. There's nothing about the regulations that explicitly address staffing agencies, but what they do is say is that if you employ CDL drivers, and so I know a lot of staffing agencies consider their employees that they place with other companies to be their employees. And so to be able to qualify them, you can go in and register as an employer, and you can designate us as a TPA and then let us handle that for you. We've had several do that. You will not have a DOT number, but there's a way to get around that in the registration process. There's a way to get around entering in a DOT number. So that's one of the biggest questions we've had. Call in and talk to your account manager. They can walk you through that.
It's great. And as Shannon mentioned, we will also help you with the driver outreach. And so as we are doing, Tenstreet is doing proactive outreach to drivers in our database to say, hey, Clearinghouse, it's a thing. Go register. Whenever you designate us as your third-party TPA, we take it even further by notifying that driver when you order those reports and kind of following through with them until they do give that consent. And so that is still, I think, from talking to clients, one of the part of the process that we're all trying to get figured out is how is that communication and that follow through, because it's not just a one-time thing for the driver. So it's a whole process. And so we're all working on that and making that as smooth as it can be.
And so certainly with this being the beginning of 2020 and the beginning of the process, drivers aren't sure what it is. They haven't been informed about it. And so it's a learning process for every one of us, but also for the drivers. And there's probably a lot of education on your front. We've taken on a lot of education for drivers as well through our Pulse Network. I know Marilyn specifically wrote a blog for our driver blog post, and then we've been sending out Pulse notifications and things along those lines. So we're trying to get the word out.
Yep. And we did have another question that came in that I thought it was a limited query for pre-employment. And again, as Shannon said, we get that question a lot. No, it's a full query for pre-employment always. And I think it's important to note that that's also for your instructors. So anybody in a safety sensitive function at your company that has a Class A CDL, a lot of times certainly your orientation instructors do, or your trainers, those folks also are subject to those regulations, not just your drivers.
So the limited queries, you can run limited queries on your current employers if you have assigned consent. And so it's important to note that limited queries are not for pre-employment. You have to do a full query pre-employment. And the limited queries are designed to be an annual requirement, just like an annual MVR. and it's just a quick run of the clearinghouse that says there is information or there isn't information. Either driver is, not prohibited, and then they can keep on being employed with you. You don't have to go in and do a full query. You have that limited done, and you don't have to do it again for another year. Or if it says you need to get further information or a full query needs to be run, then you would have to go in and do a full query, and that you would have to have the results back from that full query after the limited within 24 hours, or you have to pull a driver from the truck. So the limited query is not pre-employment. The limited query is during employment, and you do need a written consent. We have a sample written consent that we've put out, and I think it's actually in the handouts here of the webinar, the handout section, and that can be electronically signed, but you want to pay attention to the language that you have in your limited query consent. If the consent says that you can run limited queries as often as you would like during employment, then you can do that. You can run limited queries during the employment of the driver as often as you want. But if your limited consent says anything different, you do need to follow the guidelines of what that consent says. And also, if you guys have any other information, I know we just wanted to cover just a broad overview of it. We also have a few blog posts, and we've done, I think we did three webinars on the clearinghouse. So you can go to the compliance page of the Tenstreet website, and you can see the other webinars that we've had there, and then you can also pull up some of the other blog posts. We even released a clearinghouse checklist that you can go and check on the blog.
One of the questions I was going to address is how much does a full query cost? So all queries do cost the same amount. They're $1.25. You have to purchase those query plans from FMCSA's website, and you're not charged twice. So I think that was another question in there as well, is if you run a limited query and it hits a result and then you have to run the full query, you're still only charged once for that query. So it's not, it's for returned results. You're not being charged 2 times. So.
And then it's important to note that if you use us as a TPA, you still have to go in and have funds on account within the clearinghouse. We cannot, as your TPA, do that for you. That's a restriction that the clearinghouse has. So you would have to have go in, load so many queries, bundles onto your account, and then we, as your TPA, if you've designated us as your TPA and of course use our services, then we can get you get those ordered. So moving on, technical difficulties with the Clearinghouse website. So it went live January 6, 2020, and almost immediately nobody could get in. There was a wonderful 502 and 503 server errors that everybody was getting, and it was a little chaotic, and we have an in-house Clearinghouse team, and we were having trouble getting in. The communication with everyone was that they were having trouble getting in, and so it was shortly on the afternoon of January 6th that the Clearinghouse put out a notice, which we've posted on this slide, and it said, if you're an employer experiencing technical difficulties and are unable to conduct the required pre-employment full query, then you may hire a driver using solely the procedures set forth in 49 CFR 391.23E. And if you have any questions about that, that's just your normal verification process where you get drug and alcohol and accident and employment verifications, which you still have to do for the next 3 years. You still have to get the drug and alcohol information that way. And so the Clearinghouse said you can just do your normal processes through your verification of employment, and then once the FMCSA releases further notice, then you will have to go back to conducting the mandatory full query before you can hire a driver. That was up until January 22nd. And during that time period, the FMCSA definitely did a lot. You could tell it started working. It was still intermittently out. It was a couple of weeks of kind of touch and go. We had a wonderful ability to have a direct communication with people from the FMCSA that were filling us in, that we were working with, and that allowed us, if you were a Tenstreet Clearinghouse client if you used us as your TPA to give you and provide you with updates as to what was happening. And then on January 22nd, the FMCSA announced that it was now fully operational and mandatory use was now in effect. So, of course, you can go to the Clearinghouse website and you can still see that notice up today. So what that means is as of January 22nd, the full rule is back in effect, just like it would have been on January 6th, meaning any drivers that you are hiring on or after January 22nd, you must do the full query process and get the results back before you place them in a safety-sensitive position, meaning essentially before you put them behind the wheel. So a lot of questions about what this means with the delay. What does mandatory use of the clearinghouse now in effect mean? It means you have to have that full query consent. There are still problems. There are still problems with validating driver's licenses. There are still occasionally very limited amounts of time, but it still occasionally happens when the clearinghouse is down. And then we know, we're having trouble notifying drivers and getting them. We understand your struggles. We're doing everything we can, technically speaking, and, on our side to help you with that. But what it means is you absolutely have to have that full query result back showing that the driver is not prohibited before you can put them behind the wheel of a truck. So I think in the beginning, it might be just a little bit, difficult here and there. We're trying to do all we can to reduce the friction for our clients. And in 6 months to a year's time, this process will be a lot simpler. Okay, so biggest question that we've had is when is the deadline to get those full queries on drivers that you've already hired between January 6th and January 22nd? And unfortunately, we don't have a great answer for you other than as soon as possible. The FMCSA has not released a deadline. They haven't said you must get them by this date or, they can't be behind the wheel. They have not said pull them out of your truck now. They've not said any of those things. What they have said is get them as soon as possible. They made it really clear you do still have to go back and get those full queries on your current drivers that were hired in that time frame. But as of right now, there's no specific requirement or deadline. We've gotten the question, what if a driver never consents to the full query? If they're a current employee of yours, you need to be reaching out to them. You need to tell them it is required, it is mandatory, and you will have to, in addition to the full query, you will have to do then the annual query, which comes around within a year. So just make it clear to your drivers that they have to do this. This is a mandatory thing, subject to audit by the FMCSA, but as we know, also subject to inspection if they're in an accident, things along those lines. Those are what the plaintiff's attorneys and, people digging into a case are going to look at. Did you dot your I's and cross your T's on all of the processes you're required to do for your drivers? And this is one of them that is now added to that list.
And a couple of questions are coming in about how long it takes to actually run the queries and get the results back. And so on the full query, since it is required for a driver to go out and give that consent, it does happen pretty quickly as long as everything's working, but the driver has to go in. So then once you request the query, the driver will receive that notification, and then they have to go in and give your consent. And so it can all happen pretty quickly. And so if you have questions specifically about how you can run the process through Tenstreet, there's a couple questions. Please reach out to your account manager or your advisor, and we can talk you through exactly we can help you with that.
And so on that note, I just want to, we are fulfilling the requests really quickly. If there's not an error, if there's not a validation problem, it goes out and comes back very quickly as long as the driver is on the other end able to click consent. So please note that. One of the other really big questions that we've gotten a lot of, I know Marilyn's gotten this question a ton, I've gotten it a ton, is what do I do about drivers that were hired on or after January 6th, but who no longer work for me or who left before January 22nd when it was required? We know that driver turnover it's a thing, and you have to deal with it as employers. The truth is that there's not a great answer. You're not likely to get that full query. So the best thing to do is just make a note in your driver qualification file. Put some sort of note in there that says, hey, driver started on this date, while the clearinghouse was down, and left on this date, never consented to a full query, or, the clearinghouse was still having trouble during that time period, things along those lines. It would be a really good idea to make a note. And along those lines, it sort of leads into the next question, which is, should you keep records of your efforts during the technical difficulties? And the answer is yes, it's a really good idea to do so. So if you are a Tenstreet Clearinghouse client, if you use us as your TPA and you use us for your DQF, you use our safety product, we are going to automatically add a document into your DQF. It will be in its own file, which addresses the clearinghouse technical difficulties. It'll be essentially a notice in your file, and it'll say, hey, between January 6th and January 22nd, the following notice existed, and it'll have a screenshot of the notice, and then that you may or may not have been able to get a full query, and that consistent with the regulations, as soon as the clearinghouse was up and running, you were able to get a full query during that thereafter. So that's something that we are going to add in to your DQF if you use Tenstreet for safety. We're going to add that benefit for you, but if you don't use Tenstreet, either as your TPA or for safety, now is a really good time to start, because we watch out for things like that. And one of my favorite things here at Tenstreet is that I get to advise on compliance issues and really help with the steering of the products and how we do it, because we are centered around compliance and focused on compliance, and we know that you are too.
I thought we could just answer a couple of these other questions about the clearinghouse. So will a positive result prior to January 6th show up on the limited query? It's a great question, and nothing that happened before January 6th, 2020 will be in the clearinghouse. It did not go back. So it's only any incident, anything that's happened since January 6th that will be on a report.
Great question. And I just want to say a note to those of you who are also using us for your clearinghouse TPA, and that is that within your dashboard, you should be able to see where we give and post updates and notices on what is happening with the with the clearinghouse. And so please be sure to check those. We will be having another update for you soon on the errors that we're seeing. And so a lot of that is surrounding errors on the validation of a driver's CDL. And so if you are having trouble validating that, or you're seeing that error specifically, the driver's registration and verification needs to be exactly what is on their CDL license, the name and the CDL number. Another common error that we see is that you're picking the wrong CDL number. So make sure you pick the most current CDL number, and that error won't happen. We made a change just this morning, I think, to kind of help with that. But if you're seeing error on those, that's one of the things. And we'll be having more updates, so make sure you pay attention to that. Okay, some other clearinghouse just compliance things to be aware of. And again, we've got lots of other blog posts and webinars on this, so I'm going to cover it pretty quickly. There are record-keeping requirements, meaning that you need to keep query information for 3 years. You also need to keep the limited query consent on the driver for the period of employment, plus 3 years from the date of the last query that you do on them. And that is one of the sort of nuances that we built into our system, was that limited query consent is housed in a different spot in the dashboard because of that reason. And then you need to make sure you keep records on the administration of your drug and alcohol program for 5 years. That includes all records of violations, any evidence of actual knowledge violations, any traffic citations, things along those lines. One of the biggest things that I would encourage you to look at with the clearinghouse is adopting an adverse action process. If you are disqualifying or choosing not to hire a particular driver based on a violation or a resolved violation in this case, the regulations do require that you send out a subsequent disclosure under the FCRA. It's a different process than the adverse action process, but if you follow the adverse action process, it will meet the requirements of the subsequent disclosure process. So what I'm saying with all of those words is, in addition to following it for all your MVRs that you're pulling and any other background checks or consumer reports that you're pulling, SIDLIS, PSP, all of those things, this is another thing that needs to be added to your adverse action process. It's set out in the regulations itself. So, and then one of the last things that I think a lot of people were caught off guard by and weren't aware of is the policy and training requirements for the clearinghouse. So on the regulatory requirement 49 CFR 382.601 B has a list of 12 things that employers must have a policy on. And item number 12 was amended and updated to include the clearinghouse, meaning that you have to train your drivers and have them sign off on the clearinghouse training. And we have, if you use us for a TPA, we have just the clearinghouse training policy that you can get. There's no cost associated with that. And it meets the requirements of this regulation. If you don't have any training, you do need to do a training on all 12 of these items. And Maryland did an incredible job drafting up that training policy, and you can get that also if you adopt our forms engine, which there is a cost involved with the forms engine, but there's a lot of other benefits to having forms as well. And you can also have the access to that training policy for you to get your drivers to sign off on.
And there's a couple questions coming in about that. One about the release. Will there be a release form added to the now application? We have standard language you can adopt, so get with your account manager. They can send you a sample of that language, and if you want it added to your applications, then they can take care of that for you.
I think it's actually posted in one of the handouts.
It's in one of the handouts, yes. We aren't automatically, though, just adding it to everybody's Intel app. So
that's correct. Thank you for clarifying that.
So, and then is the training required for current drivers? So yes, the drug and alcohol training is required for current drivers. It was amended, I think, in 2016. Is that right, Shannon? To include the clearinghouse policy, but both of those things are required for all drivers, not just new drivers as you're hiring them.
Yes, absolutely. That is absolutely correct. Thank you so much, Marilyn. And I just want to say, Marilyn is such a subject matter expert on this clearinghouse. It has been such a nice relief to have somebody else in the office here that that can advise everybody on it. And so if you have questions, certainly contact your account manager. If Marilyn happens to be your advisor, you're in a lot of luck. And then the last thing, and it's really not a clearinghouse topic, but it kind of plays into it, is that the FMCSA announced that as of January 1st of 2020, that random drug tests need to increase from 25% of your fleet to 50% of your fleet. So we know that that's a huge extra burden on trucking companies, but it is a requirement now. What that really means is that, of course, increased costs for you, but it also means probably we're going to have a lot more reporting of violations to the clearinghouse. And so that makes it an even bigger deal to make sure you get those full queries done before you hire a driver and that you do those annual queries. And then make sure that your MROs and the people that handle your drug testing know these things, know this update, and know their obligations under the clearinghouse for reporting violations. Okay, so moving off of the clearinghouse, one of the next biggest laws to start January 1st, 2020 is the California Consumer Privacy Act, the CCPA. You've probably heard of it. It is also was passed, I think, back in 2018. And it you might say, oh, I'm not in California, so it's not applicable to me. It's more than just California entities. It applies if you hire drivers in California. It also applies if you do business in California. Now, there's some other requirements around, like, how much revenue you have and things along those lines. But it's definitely something that should be on your radar if you hire drivers in California as the CCPA. Thankfully, at the last minute, in 2019, the California legislature did carve out an exception for employment and applicant data, and that was in AB 25. So if you heard a little bit about those numbers, that's what that was. It was carved out an exception to the CCPA, saying you don't have to follow all of the CCPA requirements with regard to employee and applicant data. Only some were retained, but there are still rights retained that we're about to go over. But I just want to note that it's only a 1-year exception that's carved out. We don't know what's going to happen in that year. We don't. So January 1 of 2021 will be very interesting to see what happens with the CCPA when it comes to employee and applicant data, because the other requirements of the CCPA are things like if a consumer requests that you delete their data, you delete their data. Well, obviously that places a really large hardship on employers, because you need to keep that data about your employees. But that's not in effect right now, and hopefully will be changed or extended beyond just 2020. So some of the rights that were retained and things that you need to know about and you need to be cautious of are the requirement to give employees or applicants notice at the time of collection. So what are you supposed to give them notice of? You need to give them information about what is collected, why, and how the information is used and disclosed. If you sell any of the information to third parties, which most of you don't do anything along those lines, particularly with your employer applicant data, but that's a really big one, and that's what the CCPA was really designed to curtail, is the selling of data, or at least informing consumers about what goes on with the selling of their data. But you do still have to give them notice. So you have to say what kind of information you collect, which is, if you're doing it through the application process, is a lot of sensitive information. And so you're going to want to put that in a privacy policy, and you're going to want to, and I'll cover privacy policy here in just a minute too, but you're going to want to link that then to your Intella app, or anywhere where you are collecting that kind of information online. You're going to want to put your privacy policy, because that would give them notice at the time of collection. And then the other right that was retained is that companies can be liable for a security breach of data if certain security controls were not met or were not in place. And so what that means is that actually the California Attorney General put out sort of a recommendation saying that these security controls, if these are in place, then that would meet the minimum security controls that are necessary to try to prevent a security breach. And so if you have those controls in place, then you're a lot less likely to be liable for a security breach. And just so you know, Tenstreet, we take security very, very seriously. We do have those controls in place. We meet those plus more. There's actually a article on our blog about our security controls that our director of operations drafted up, and it's wonderful and talks all about the extent and of security controls we have and how much importance that we place on those. And then we are also waiting on regulations from the California Attorney General about just the CCPA in general, but that we believe will also apply to what is going to happen and what needs to happen with employee and applicant data. And those regulations are supposed to be out by July 1st of 2020. So the CCPA has kind of been a rough start getting off the ground. There's not full enforcement yet. We don't know what full enforcement will look like. So now is the time. Go update your privacy policy. I can give you, if you needed, the names of specific lawyers that can handle CCPA compliance for you. And then make sure you get a privacy policy uploaded onto your application and anywhere else where you're collecting employer applicant data.
So did you see the question about, will the California Privacy Act apply to third-party recruiters or just the carrier that hires them?
So that is a pretty detailed question on whether and how the business operations of the third-party recruiter are. If the third-party recruiter meets certain standards for California, hiring in California, doing business in California, it could apply to them. You kind of have to dig in. There's a couple of other little factors that they would want to dig in, so they should probably talk with a CCPA attorney about that. Even just do some basic online research about the CCPA. You can get some answers to that. But if you're collecting California consumer data, it's likely that it does apply to you.
Thank you.
Okay, so then moving on to the next slide, let's talk just briefly about privacy policies. California, if you hire in Canada, you absolutely must have a privacy policy, and you have to have a place where the person consents to the privacy policy. So get a privacy policy in place. Even if you don't have operations in California or Canada, or the CCPA doesn't apply to you, or you don't think it does, privacy policies are spreading across the country. This is the new ban the box. There is a New York Shield Act, which was recently amended. It's not to the extent that the CCPA is, but it does still require that you give certain notifications upon a data breach. It does require that you have certain data security requirements in. It applies if you handle any data of New York residents. So it's another broad one. I expect to see these privacy laws across the country, if not a federal privacy regulation, come out definitely within the next 2 years, but certainly within 2020. I think a lot of these laws are going into place. And so, again, you want to post your privacy policy wherever you collect information. I've got a picture here of Tenstreet's privacy policy. It is at the bottom of every single page of the Intella app. And if you send us your privacy policy, all you have to do is send a link to your privacy policy to your account manager, and we will add it right there next to Tenstreet's privacy policy. Privacy of data is a really important topic today, particularly sensitive data, name, date of birth, social, things like that you're collecting on these applicants. And it's going to become a really important topic, and being transparent and on top of your data practices will be something that you're going to want to do. Okay, so moving on. California's AB5. This has been something that I know employers across the country who hire in California have been watching. So AB5 actually started from a case that was decided saying that independent contractors need to pass this ABC test. And then the California legislature jumped in and said, no, we're going to make it law that if you are hiring in California, effectively, it presumes that anybody working for you is an employee instead of an independent contractor or an owner-operator. And so what they said was you have to meet the requirements of this ABC test, or they are an employee. That was supposed to go into effect January 1 of 2020. I'm sorry, it did go into effect January 1 of 2020. However, and the ABC test, let me cover that really quickly. The ABC test is A, the work is not controlled or directed by the hiring entity. B, the work done by the contractor is outside of the hiring entity's scope of business. And C, the worker is regularly and independently engaged in the type of work. And so for most trucking companies, for most carriers, meeting B is almost impossible because the scope of your business is moving freight. And so there were exceptions made to AB5 that the legislature drafted in, but they did not include the trucking industry. Mainly, they were trying to target the gig economy and Uber and those kind of driving services. And in doing so, it also is negatively affecting the trucking industry's ability to hire owner-operators because of this. So what happened was the California Trucking Association jumped into action and filed a lawsuit challenging AB5, saying that it was preempted by federal law. And so as we're going to see on the next slide, actually they were successful, at least temporarily. On December 31st of 2019, in this case, in the federal courts, brought by the California Trucking Association, a federal court judge issued a temporary restraining order restraining enforcement of AB5 to trucking companies. Shortly thereafter, on January 10th, in another case, a separate case, the California State Court said that AB 5 was also preempted by federal law. All of these were really good things. And then on January 16th of 2020, the federal court, in the case that was brought by the Oklahoma Trucking Association, issued what's called a preliminary injunction, which restrains enforcement of AB 5 to trucking companies while the case is pending in the court. So right now, as of today, AB 5 does not apply to trucking companies, to motor carriers. However, you need to stay up to date on this and on what's going on, because that could change if anything changes in the court case. And so just to kind of tell you what happened during that case and what's happened so far, the court said that federal law, and this is a quote from the court ruling, likely preempts an all-or-nothing state law like AB 5 that categorically prevents motor carriers from exercising their freedom to choose between independent contractors or employees. Like I said, this injunction is in place while the case continues. Just sort of a legal note, to even get an injunction, one of the standards is that the injunction, the person who is asking for the injunction, has to be likely to prevail. That is the standard to get an injunction. And so when the court ruled on this, the court was saying they believe it, essentially saying they believe that the California Trucking Association is likely to prevail. But it's not a slam dunk. And as we know, litigation can make many turns and a lot of things can happen. For example, this injunction decision is likely to be appealed to the Ninth Circuit Court of Appeals. The Ninth Circuit has traditionally not been very friendly to trucking companies and to laws such as this. So we will see what will happen. Keep following along, keep following our blog, keep staying in touch with the industry, because this could change as the case changes, and suddenly owner-operators in California could become employees. So you're going to want to make sure you follow this. There is a motion to dismiss the California Trucking Association's case, and that hearing is going to be happening on February 3rd, and we will be following that along. But just to note, there is a New Jersey bill that is almost exactly similar to AB 5 that exists right now in New Jersey. It's the exact same ABC test. And it's something that you're going to want to follow, because New Jersey could adopt the same thing. And we don't know. Right now, there is no talk of an exception for the trucking industry. It's not finalized yet, so there could be an exception drafted in. But you're just going to want to watch. I think that this test and these types of legislatures jumping in and mandating these kind of things are going to start spreading across the country too. Everything that kind of happens in California, we see spread across the country. It'll go, up into Washington and then spread over to New York and down through there. So just keep your eye out on these, and we certainly are as well. Okay, so along those same lines, owner-operators versus employees. Because of the ABC tests, but also because of very, very costly misclassification class action lawsuits that we saw that's been trending for a long time, but also in 2019, it has never been more important to draw a very clear distinction between your owner-operators and your employees. If you hire only owner-operators, you want to make sure that your processes are in place strictly towards owner-operators. If you hire both, or you have separate entities that hire both, you're going to want to make sure that you draw a clear distinction. The best thing to do is to have two different Intella apps, one for your owner-operators and one for your employees. That way you can set up everything along those lines, one tailored specifically to owner-operators, the other one towards employees. It's not required. That's not required by law that you do that. That's just a best practice. If you do have just one Intella app for both, you're going to want to make sure that all your documentation, all your releases, any forms you send out, things along those lines, comply along the lines of they address both employees and owner-operators. So if you adopt our standard release language, which is in one of the handouts, because we're going to talk about it here in a few minutes, it is drafted in to apply to both owner-operators and employees. And that language is drafted in. Same with your adverse action letters. Other things that you want to make sure you're considerate of is if you have if you're hiring owner-operators, you're not going to want to get I-9 signed by them. That's only for employees. You're going to want them instead to fill out a W-9. Same things with other forms and other practices and contracts that you get. Just to point out how big of an issue this is, we saw misclassification lawsuits in 2019 at a very, very large number. As you can see, there was one case in particular that had a $100 million settlement. We saw another one with a $3.5 million settlement. I mean, going back in time, these have always been big. $22 million settlement in 2013, $12 million in 2014. There was a really bad case in 2015 that settled for $228 million. So these are big cases. You definitely want to draw a distinction. You want to be careful here. And you probably, if you hire owner-operators, you really need to speak with an attorney who can represent you, that can give you advice and look over all of your practices and make sure that you have your I's dotted and your T's crossed on all your owner-operator classifications and documentation and everything. Did you have anything on that, Marilyn?
No, I do not. I did want to just ask one question about the California stuff. So a question that came in that says, can I pass on an applicant because he lives in California because I'm not CCPA compliant?
That's a great question. And so I would say if you are just hiring, very limited drivers, and if you don't have regular hiring in California, and you just have one driver that you're hiring, the CCPA requirements might not actually apply to you because there are other requirements that go into it. Like you have to have a certain level of revenue and you have to have other things. But like I said, California is not going to be the only one. So I wouldn't necessarily pass on that driver. I would get a privacy policy in place. And I would still hire that driver and just work on being CCPA compliant and use 2020 as your year to do that, because I think throughout 2020 and going into 2021, we're going to see these laws really apply across all states, and so that would be the best thing to do. So moving on to ban-the-box laws, of course, we had a number of ban-the-box states that were added or that either amended, updated, or added a ban-the-box law. And so if you're not familiar with what that means that you, in these states, there are other requirements that vary by state, but the biggest thing is that you cannot request criminal history information on the application. That's sort of what it's known for, but I want to be very clear that it differs by state, and some states have more stringent requirements than others. And without digging into each state law, I couldn't just give a broad overview. But the best thing to do is make sure you have no criminal questions on your application. These are just the new states that were added in 2019. And then there are a few others that are out there that are going into effect throughout 2020. And of course, there will be more added in 2021. But there's already other states than just these that are in effect and in place. These are just the new ones in 2019. I want to mention here that we have some really great functionality with our system. If you have a criminal page or MVR section that has criminal questions on it, our functionality detects where the business is located and where the applicant is from. And so if the applicant is from a ban-the-box state, applies from a ban-the-box state, say Colorado, then those criminal questions will be removed for that applicant, but they'll be there for, say, an applicant in Oklahoma, because Oklahoma doesn't have a ban-the-box. So be sure to be aware of that. But really, overall, best practice is just take any criminal questions off of your application and follow up with those later on in the hiring process. I do want to say that our functionality really only applies if you're a private employer. It does not apply to federal contractors, which leads me into one of the newest things that came out in the ban-the-box world is the Federal Fair Chance Act. It was passed December 20th of 2019. If you're a government contractor, a federal government contractor, you cannot request criminal history information prior to giving a conditional offer of employment. So just be aware of that. One of the other things that I get questions a lot on is when you're setting up, your application, or you're going through and reviewing your application. There's an FMCSR required question, which is, have you had a drug or alcohol violation in the last 2 years? That is required by the FMCSR, and that does preempt any state ban-the-box law. However, if you change that question or you amend that question on your application to say, have you ever had a drug or alcohol violation, that is not protected by the federal regulations. So, and that would fall under what these ban-the-box laws are prohibiting. So please be wary of that. Be wary of the custom questions that you have, and make sure you're complying with these state ban-the-box laws. There's a link to NELP, which is updated all the time. I think I passed it over to you if you want to post that in the chat. If you have questions about individual state ban-the-box laws, this is a really, really great resource that you can check out. That's okay. And then going on to the next slide, we are going to talk about pay equity. So pay equity laws are, as you can see from this list, just going around the country. They are being adopted at a faster rate than the ban-the-box laws are. These are the ones that were adopted either in 2019 or the beginning of 2020. And I mean, New York, New Jersey, Alabama, Maine, Missouri, Kansas City, Ohio, Colorado, Columbia, South Carolina. I believe that by the end of this year, by the end of 2021, there will likely be a federal pay equity law. So what this means is essentially you cannot discriminate either on the basis of gender or on the basis of other factors like race, disability, things along those lines, in pay. And obviously with the Me Too movement, the pay equity laws are really marketed towards gender, but they also apply to minorities and other things. So please make sure you're being cautious of those as well. So how this applies to the trucking industry is if you have a question on your application of how many cents per mile do you currently make, these state pay equity laws are going to prevent you from asking that question, or really any other questions about pay. They all differ, just like the ban-the-box. They differ among the states, and without digging into the particular state, I couldn't tell you what the exact specifics are. Some of them say you can ask, like, what do you want to make? But some of them say you can't even talk about pay until after you've made a conditional offer of employment. So just be wary of that. If you use Tenstreet's functionality, we do sort of a similar thing to the ban-the-box, which is in any of these jurisdictions, we will take that pay question off of your application if the applicant applies in one of these jurisdictions. So just be aware of that. These pay equity laws are really big deals coming out across the country, across all industries. And I have heard that there are several state attorney generals that are going to be going in and doing audits of employers. So it's something that you definitely want to have on your radar.
I'm going to ask, we have a couple questions that came in on the ban-the-box stuff. And one was about where we would put that info. In the comments section or the handout section, we'll put the link to NELP. As soon as we finish with the slides, we'll get that out there, and that's what keeps you up to date on ban-the-box stuff. And then the other question, Shannon, that came in is about the criminal questions. So it says, am I correct that you said criminal questions shouldn't be on the application? And so I thought maybe you could just address that again.
That is correct.
Yes. So
you should not have criminal questions asking about criminal histories on your application. That is absolutely the best practice, because it would run afoul of these ban-the-box laws. And so if you are asking a question that is required by the regulations, by the FMCSRs, then that can be on your application, because those are federal law that preempts these state ban-the-box laws. But if it is not a specific question, pretty much verbatim as required by the FMCSR, then it can be considered outside of those bounds and can be considered a violation of the ban-the-box laws.
Thank you.
And so I am actually going to post in the chat. I think I can do it here. Yeah, great. There we go. So that's the NELP guide. I'm not really technically savvy, so don't laugh at me too hard. But yeah, the ban the box laws, be very careful of those. Be wary of those. Go through right now and audit your application and make sure it says and reads exactly how you want.
And then there is one question about the pay equity laws. Do they apply to independent contractors?
So that is going to get that. That's a very good question, and that gets into kind of the nitty-gritty of each state law. Each state law could be different. For the most part, it probably won't apply to independent contractors, but what you're going to want to be wary with on the independent contractors is more of the misclassification between whether they really are truly an independent contractor or they're an employee, and then one of the other things we're going to talk about, which is to make sure they are at least being paid fairly under the FLSA. So on the pay equity laws, though, it's just a good practice unless you kind of dig into each individual pay equity laws that apply to where you're hiring. It's hard to answer that question because it could, but most of them don't. Most of them just apply to for employment. Okay, moving on. Significant cases that we have talked about. And so last year, shortly after the beginning of the year, I think it was maybe March or April, the Ninth Circuit released a Gilbert versus California check cashing case, an opinion in that case, which was really significant in the FCRA space, which is with regard to your FCRA disclosures. What the Gilbert decision said, the facts of that case were, and I did a webinar on this, and there's actually a blog post out there on our compliance page that you can check out, that what that actually did, there was a California notice in the FCRA disclosure that this particular employee had, and the Ninth Circuit said, absolutely no extraneous information can be in your disclosure. And so even that California notice, even though it applied, to the FCRA and to what they were pulling, they still said, nope, you've got to have only the FCRA disclosure, no state law notices combined with the FCRA disclosure. And the wave of FCRA litigation has been cutting down on what you can have in your FCRA disclosure. They've said absolutely no extraneous information, meaning no waivers of liability, and no employment policies, no anything else. And this one was a big one that said you cannot even have state law notices combined with them. So check out our blog post. We'll put that in the chat links. Also look at the compliance page. We've got I did a whole nother webinar early in 2019 addressing this. And then if you haven't updated your disclosures and authorizations in the last year, you're going to want to do that. And one of the handouts that we've put in this webinar is our sample disclosure and authorization language. Take a look at that. If you want to adopt that with your Intella app, make sure you get with your account manager and they will get that implemented. FCRA lawsuits are at an all-time high. We don't have the numbers out for the full year of 2019. It's still January, and we're still waiting on the summary of all of those things from the publisher who releases them. But what we did see is in October of 2019, there had already been an 8.7% increase of FCRA lawsuit filings than the prior year, than 2018. And 2018 was a record year. So I think 2019 was going to be another record year. And let's not kid ourselves, 2020 is going to be another record year for FCRA filings. We do have knowledge of other FCRA cases right now against carriers that are going on, that are being filed. And it's not just costly, but it is a heavy burden. So I'm going to kind of fly through this. We're almost out of time. I appreciate you guys being with us for an hour, but one of the other areas you're going to want to be watchful of is the TCPA. That's the Telephone Consumer Privacy Act that applies if you are texting your drivers. Last year, there was a $61 million award against a company based on the actions of a third-party marketing agency. So make sure that you get the consents, the opt-ins for your drivers before you text them. TCPA lawsuits were also on the rise. We saw an arbitration case in the Supreme Court which said, hey, arbitration agreements for independent contractors, you cannot compel arbitration under the Federal Arbitration Act for those because they do fall under the exception for contracts of employment. So just know that if you hire independent contractors and you have an arbitration agreement with them, it might not be enforceable. And then we saw significant wage and hour cases in 2019. One of the more interesting ones that applies to carriers, it was around sleeper berth time that may be compensable. There was a DOL opinion that was released, and there were two cases, one out of Arkansas and one out of Massachusetts. Essentially what they said was that while a truck driver is just riding, it can be considered working except during bona fide meal periods or sleeping time, and that if a team member, if they're driving in a team, and if a team member spends more than 8 hours in the sleeper berth, that time might be considered compensable. Make sure you've followed up and done a really good review of the time and how you, I know since the trucking industry, you pay per mile, things sometimes don't work out right. You don't want a DOL audit. It's going to be very, very difficult. The DOL would come in, do an audit, make sure you've got your I's dotted and your T's crossed, and get with legal counsel, because wage and hour cases are on the rise across industries, but we have also seen many, many wage and hour cases in the trucking space in particular in the last year.
And the only thing I would add to that is with the ELD mandate that's now in effect, make sure you understand how the visibility that you have to that data is now a little bit different than maybe it was before with paper logs, and where you're storing that data and what could be asked for if you were to be audited by the DOL. Just make sure you're really familiar with how to extract that data and you're saving it the appropriate amount of time.
So here is the last page, 2020 forecast. This is my crystal ball. Everybody asks their attorney for a crystal ball. And if you talk to any good attorneys, they say, I wish I could give you a crystal ball. Well, Leah gave me one when she helped me with the slide deck. And so obviously I don't really have a crystal ball, but I think there are going to be in 2020 more data privacy laws, which will include notice requirements for employers. There are going to be more ban the box and pay equity laws, more states adopting the ABC test, more FCRA class action lawsuits, more TCPA class action lawsuits, and more wage and hour lawsuits. So please, please, please make sure that the beginning of the year, now's a good time. Go through, audit your stuff, make sure you're compliant, look over all of these things, and contact your account manager or your advisor if you need any updates to your processes. I really appreciate you all hanging in here with us for this hour. I know we're going a little bit over, and I do want to get to your questions. Just before I get to those, I want to make sure and tell you all about our user conference that'll be in Vegas, April 15th through 18th. We've talked about a lot of compliance issues today. I will be in Vegas at the user conference talking about more compliance issues, but we will also have other expert leaders like Maryland and Tim and Brian who will be there ready and able and willing to meet with you and answer your questions and talk about these things. You can set up meetings with us. We will have a help desk where you can set up and interact with people to be sure and get your questions answered, and having somebody sitting across from you face to face really goes a long way. And then we'll also be releasing a lot of really fun product information. Last year, we announced a lot of products, new product information. And this year, in addition to announcing that product information, there is I got a little bug telling me that there's a high chance that you can get even free stuff, meaning like free access to some of the new things we roll out for the first 90 days. So that will benefit you. And then just having your voice be heard. The last day of our user conference last year, Tim and Elizabeth were really great, and they said, hey, we want to hear from you. What do you want to see? And we actually included that in most of our products that we rolled out for the next year up until now. And so a lot of those suggestions that were made by you all, by our clients, we took to heart and we put into effect. And so get your voice heard. If you have something you want us to do, show up at the user conference. vote, talk to us about it. We want to hear about it. So sign up. We're going to post the link in
there. It should be in the chat.
Awesome, in the chat, and sign up for the user conference. Okay, so what questions do we have?
So we've been answering a lot of questions along the way, and so some of them that we haven't gotten to yet require a little bit more explanation, and so you will get an answer to them. We're just not going to address them here in this forum, but a couple of them that we did want to talk about is there's a question about how you can assign us as a TPA. Is it done through the FMCSA portal or from the Clearinghouse? So it is done. You do have to go to the Clearinghouse portal to assign us as a TPA. You can, again, contact your account manager or your advisor, and they can walk through a series of questions with you to make sure we get you set up properly so that you can take advantage of those services, but you will have to go into the Clearinghouse in order to assign us as a TPA. Yes, and you also have to purchase your queries on their website, and then we can run them on your behalf.
We're going to give out a link to this presentation. Right. It will be in your inbox within 24 hours. If you had to jump off early, or if you want to send it to somebody else to look at, you can always also go to our compliance page on our website, and all of these are linked there, and will be there within 24 hours. And if you have other topics you want to hear about, we get a lot of people on these compliance webinars, and I am committed to doing these and continuing to do these throughout the year. So I want to know what topics you want to hear about and want to learn about. So send them in your questions or in the chat. Send them to your account managers. Say, hey, we want to learn more about this, and we will definitely incorporate those. But we will also get to your questions. If we haven't answered it, we will send out an email responding to your questions. And we just really appreciate you guys being on here and joining us for the last hour.
Yep. Have a great weekend, everyone.
Bye-bye.